Hello, I'm Lydia Hayes. It's delightful to see so many of you here today. The discussions that we're going to have this morning really are to set the scene for this afternoon when we have our three speakers. We'll be talking about their recently published work. The focus for today is on methodology and methods. It's about how we go about studying law and gender, specifically to look at how we approach doctrinal studies in particular as legal scholars. And so the presentations by myself and Sharon this morning are really a sort of mini introduction to that. I'm just coming to the end of a junior research fellowship that I've had here, thanks to sponsorship from the Journal of Law and Society. During the time of my fellowship, which has lasted for about 2.5 years now, I've concentrated and focused my study on home care workers. I am a labour lawyer, but I hope that by, I'm a labour lawyer, but that's a good sentence, isn't it? I hope that by talking to you about methodology rather than the specifics of labour law, what I have to say will be of general applicability. So home care workers. They are people, predominantly women, who provide essential support to older and disabled people who live in their own homes. So in the UK, 80% of the home care industry is financed by the state. There are various different forms of employment relationships in which home care workers are engaged. But between the different variations, anywhere between 80 and 95% of the workforce are women, and the workforce is perhaps a little larger than you might imagine. There are 1 million women who are involved in home care services, the provision of care at home in the UK, and that number is predicted to rise to 2 million within a decade. It is now the largest source, the adult social care sector is now the largest source of employment for low-waged women within the UK. The study that I've been involved in as part of my fellowship has formed the basis of a monograph called Stories of Care, a Labour of Law, Gender and Class at Work, which will be published in January 2017. The methodological perspective that I've used confronts the gendering of knowledge and has made it unavoidably at issue in my own research. So the question that I'm thinking about with this presentation is the gendering of knowledge at issue in legal research? And I've come to realise by thinking about this presentation that studying home care workers is in itself a methodology. And it's an approach to the doctrinal study of law which could be adopted in relation to other groups. So, for example, steel workers, construction workers, childcare workers. Each of these categorisations or labels for labour carries gendered meaning. And when people carrying these labels appear before courts or tribunals as claimants, they represent the physical embodiment of those gendered meanings. And hence, when their circumstances, dilemmas and situations are presented as plausible facts, how are they interpreted? And what role does gender play in decision making? Now, in my study, I've applied this method so far to issues to do with working time, national minimum wage law, transfer of undertakings law, that's to do with contractual protection when a business is bought and sold and workers move from one employer to another, unfair dismissal, protection periods, equal pay law, the application of criminal law within the home care industry, and the list is growing. And the point that I want to make here is that I'm not doing an inquiry into labour law that focuses on the most obviously gendered aspects of the employment rights repertoire. Not that that isn't important, it most definitely is. issues such as part-time workers' rights, access to facilities for breastfeeding, maternity and paternity leave, protection against sex discrimination. These are Parliament's response to some of women's most urgent concerns at work. However, about 18 months ago, I did a piece of research with Roseanne Russell, who's sat at the back there. Hi, Roseanne. And we investigated the context and frequency of women's inclusion in labour law scholarship over 40 years of publications in the Industrial Law Journal, which is the UK's key publication for academic scholarship in labour law. And we found that over 75% of the occasions when women were actually mentioned by reference to terms such as she, her, female, woman, etc., they were included as a consequence of their identity as wives and mothers. So, for example, maternity, paternity, pension, sex discrimination, breastfeeding. Instances of women being included as research subjects in what might be termed generic labour law research about contracts, unfair dismissal, redundancy, trade union rights. Women were rarely mentioned, and this in itself tells us something about the gendering of knowledge. The assumption that workers are bound up with notions of masculinity, with the ideal of male economic provision for families and of the stereotype of the breadwinner, something that Joanne Conahan has written about extensively throughout her career. And what Roseanne and I found promising, though, was that the balance between research about women as mothers and wives and workers, and about women as workers who have economic interests, a need for stability, and as contractual actors with a lack of bargaining power in relation to employers, that balance had become more even as labour lawyers were increasingly beginning to show an interest in developing original empirical material upon which to base their understandings of law and doctrinal inquiries, something which Lizzie Barnes has been writing about recently with a great deal of passion and commitment. So back to my home care worker research. The piece of gendered knowledge, which is at issue, as I discovered in my research, is the knowledge that caregiving rests on a one-to-one, non-commodified, nurturing relationship between a caregiver and a care receiver. That care is co-produced between those two parties and within this relationship. And this knowledge is not only gendered, it's classed. But setting aside the classed aspects of this for a minute, it's about pulling across understandings of unpaid care work into a paid care work context, which is a commercial environment and is ruthlessly cost sensitive. And it's not only an inaccurate portrayal, it's also one which virulently operates against care workers when they come to make claims. So it's my methodological assertion that, although I'm sure I'm not alone in thinking this, that the gendering of knowledge is particularly prescient concern in research about law. And why? Because the gendering of knowledge is a social phenomenon, and at its heart are questions about masculinity, femininity, power, authority. And in the natural and physical sciences, concerns about the gendering of knowledge has traditionally focused on exposing masculine bias about drugs trialled on men and not on women, of clinical and biomedical research impacted by the selection of male-dominated research populations, of the gendered organisation of results, of equipment designed with male attributes in mind, weight, calorie requirements, all of those sorts of things, and the virtual invisibility of women within research protocols. But when the gendering of knowledge is expressed in law, it carries special significance. Law is a language of power. It communicates the authority of the state, and it's necessarily collective in its development, yet individual in its application. Law speaks for us, and to a large extent it determines what passes for truth, because the law functions to establish fact upon which judgments are based, and legal knowledge is built as precedent passes from one case to another. And law And truth is not only objective fact, determining if something happened or not, and if so, what that something was. It also plays with behavioural truths about human beings. So law's gendering of knowledge is also a form of knowledge about gender. This is what people do, how they respond. This is what men are like. These are the appropriate actions or responses of a woman in a particular situation or circumstance. And it's not difficult for us to come across empirical evidence that our social structures are gendered. Family, parliament, labour markets, property ownership, they're all gendered, but law has a pivotal role in coordinating the gendering and securing the gendered hierarchy inherent in all of these social fields. So in questioning whether legal research engages with the gendering of knowledge, we locate legal inquiry as a form of epistemological investigation. And I think a definition of epistemology used by Linda Alcoff is helpful. She says that epistemology is a philosophical inquiry into the nature of knowledge, what justifies a belief, and what we mean when we say a claim is true. And this maps well onto legal research. We can dissect its component parts. What is legal knowledge? How does law justify belief? And how does law determine truth? And if legal research is an epistemological inquiry, and if knowledge is gendered, legal research is always dancing on the ground of gender. Masculinity, femininity, power and authority are ever present. The greater access to law any particular social group or community has, the greater their ability to define knowledge and to do so from a particularly socially situated position. And it matters for us because it influences the development of law. It determines the questions that courts are required to answer, and it shapes the information that's laid before judges. Law is not a body of value-free principles. Whether generated by politicians or legislators, or judges as lawmakers, the law serves to protect interests and endorse values which they determine. As a consequence of the history of knowledge production, research and theory has overwhelmingly been generated by men, and their view of the world and their understandings have provided the standard against which other ways of knowing the world are benchmarked. That knowledge is not only the standard, but it's also the neutral. Additional viewpoints are other, marginal, quirky, alternative. But most often, even as other, additional viewpoints are not heard. The term gender provides an example in itself. Gender is the social expression of sex, and while we recognise in a contemporary context that sex is not a binary product of men, male or female, women are not the only sex. So why does gender typically operate to mean women's stuff? And that's because supposedly non-gendered investigation, or investigation which ignores gender, is male, the standard, the supposedly neutral, natural norm against which studies of gender, i.e. women, are understood. Another example of the way in which gendered knowledge communicates social hierarchy is packaged up in the word mother. Clearly a gendered term, since mothers are women and distinguishable from fathers, although both are parents, but nevertheless, mother communicates more. We have single mother, surrogate mother, working mother, stepmother. So the unadorned word mother means a woman with children that she gave birth to, who is married, depends upon her husband, and is not employed outside of the home. And this is the standard mother. The modified versions are substandard. They don't quite meet the full definition of mother, and they need some additional explanation. So what about the gendered knowledge wrapped up in the term worker? Because we have a huge number of variants, like part-time worker, casual worker, seasonal worker, migrant worker. Such linguistic arrangements reinforce the normative traditional standard of employment in which men go out to work as standard, stable, regular arrangements. For the unadorned term worker communicates that work is the central plank of their identity. It's their natural home where they fit within that term without modification. So, for instance, for a part-time worker, the point being made is not necessarily the modification about their working hours so much as that they are something else, that they have a different being, that they're not wholly committed to work. And since we know that 75% of part-time workers across the working lives are women, and for women between the ages of 25 and 45, the proportion working part-time is much higher, the counterpart to their identity as worker is as a giver of care. Now, in employment law, this hierarchy of gendered knowledge is expressed through the notion of two-tier status, either an independent contractor or an employee in common law as a worker or employee according to statute. But either way, the strongest suite of rights attaches to people in relations of employment most closely fitting the masculine ideal. Space is gendered with a key division between home and the wider world. Home is culturally associated with a natural order as a place of rest and comfort. And we see this reflected in working time law, which Anya will be talking to us about later. But an example would be the case of Truslove and Scottish Ambulance Service, where an employment appeal tribunal was asked to determine whether ambulance workers should be accruing their right to rest during times when they were on call. Some of the time when they were on call, they needed to wait around the corner, and some of the time when they were on call, they were allowed to wait at home for their next call. So the determination was that when they were waiting around the corner, the clock was still running as far as their working time was concerned, but if they were at home, the clock stopped. They were no longer at work. And the reasoning for this was because of the quality of rest which they would get at home. Now, for women with children at home, it may be much more restful to actually wait round the corner. So we can see that this is a gendered interpretation of the home as a place of rest. And where else does this knowledge about home appear in working time? We see that live-in domestic workers are excluded from key provisions limiting working time and rest periods. So, as a consequence of their specific exemption within the working time regulations, there's no limitation on a maximum working week of 48 hours, though other workers have the opportunity to opt out. That isn't available to domestic workers. There's no limits in terms of night work. There's no requirements for them to have health checks as a consequence of night work, etc. So, bearing in mind that these are all health and safety provisions, it's hard to think that the law is actually saying it's okay for domestic workers to damage their health and safety, but not for everybody else. It's more plausible that the law is actually reflecting a body of gendered knowledge in which the home is not really a place of work. And so whatever it is that domestic workers are doing, it's not work, as it's a form which is fully and unequivocally recognised in law. And whether it's the emotional or the affective labour that we associate with caring for vulnerable people, or the messy, non-physical contact work of sort of laundry, cleaning and cooking, domestic work is care work, broadly defined. So, as I suggested a moment ago, from a gendered knowledge perspective, the opposite of a worker is not an unemployed person, but a carer. Much academic writing focuses on the idea that care is an individualised practice, an individual experience, and it's this individuated relationship between a care receiver and a caregiver. And much of the purpose of this scholarship has been to challenge the erasure of relational care, particularly in the context of privatisation, the commodification of care within social care markets, and the way in which anything that can't be packaged into contracts is simply overlooked. So for all of these reasons connected with the gendering of knowledge, it's been particularly interesting for me to consider what happens when a home care worker comes into contact with the law, because these claimants embody specific gendered meanings, and because their identity comprises the sort of polar ends of some of the spectrum of gendered knowledge that courts are dealing with when they're making determinations in relation to employment conflicts. And judicial decisions and the shape of statutory provisions reflect the gendered knowledge which is bound up within the idea of a home care worker. So I've been, my methodology, examining and reviewing case law to see if we get different outcomes when home care workers bring claims as compared with when other workers do, and to think about how this influences the development of law and what home care worker means when it's reflected through the lens of different forms of judicial doctrine, statutory entitlements, even with regard to the potential for prosecution in criminal law. And the results have been interesting indeed. Individualised understandings of care work have shown up in judicial comments in relation to home care worker claimants, in relation to equal pay claims. So just very quickly to repeat a phrase used by Justice Alliance in Cumbria County Council and Dow. Home care workers had made claim with a male worker who had been rated as equivalent with them, but was paid a productivity bonus. And the question was whether the care workers were entitled to a productivity bonus. And the comment was, a care worker who works properly is subject to the demands and requirements of the patient and cannot sensibly dictate the speed of working. So this formulation of what it is to be a care worker completely lacks any recognition of the presence of an employer controlling a work rate or requiring the woman to take responsibility for deadlines. As I said at the beginning, this is a hugely pressurised and cost-pressured environment. The suggestion that the home care worker works properly when she has no control over her own work rate, the use of the word sensibly to suggest that it would be kind of folly for her to kind of try and do otherwise, the image of her being subject to the demands of this patient invokes notions of women's subservience and the needs of response to the need of other people. So there's a significant difference between this judicial view and the gendered knowledge which is wrapped up within this, and the reality of people's working lives within this very pressurised environment. So this also shows up, for example, in relation to claims from national minimum wage law, where the only work that counts is work where care workers are awaiting the demands of the service user, and their working time is calculated on the basis that they actually physically are engaged in tasks to provide care to their service users, but in between times the employer is able to negate that time as being working time, even though they're contractually obliged to be in attendance. It's also shown up in relation to unfair dismissal law, in terms of service qualification rules, which have recently been considerably tightened since 2012, in relation to the way in which the rules around qualification entitlements actually encourage the organisation of the industry in ways which reinforce a non-rights holding status of home care workers on the basis that the employment relationship is not significant within this one-to-one relationship of caregiving. Also in relation to service transfers too. So, is the gendering of knowledge at issue in legal research? Yes, it always is, and not only in relation to women's stuff. The assumptions of gender neutrality, which inform law, are infused with understandings of masculinity and femininity, and require investigation and critique in pursuit of legal decision making, which is based on more accurate information, which genuinely reflects social life.